Hi, everyone. Thanks again for coming.
All right, let's settle down.
Coming in.
Program's going to start.
Hi, everybody. Welcome. Thanks so much for attending this year's SEI Supreme Court term preview. I'm Debbie Schrader. I am the director of the Supreme Court Institute, and this is an annual event where you get to hear from Georgetown law professors about some of the most important cases that are pending before the Supreme Court. We have given you two handouts. One gives you a little background on the cases that are going to be discussed, and the other tells you how to sign up for an SEI court if you haven't done so. We are really excited about the panel we have for you today, and after this event, we are going to go outside because the weather is cooperating, and there will be ice cream served. So, looking forward to that. Thank you for that applause. I appreciate it.
But you can only get the ice cream if you were here and you can answer questions about the case.
Welcome, everyone. So thanks for coming, and we'll spend the first hour or so presenting cases, 4 cases, and then between 15 minutes and a half hour of taking your questions. I want to give a brief introduction. If you look at the term before the last one, there was a lot of evidence that the court had quickly become a 6-3 conservative Supreme Court that was moving very quickly and very fast and very far in a rightward direction. In the top 4 cases, including the overruling of Roe against Wade and Dobbs, the court divided 6-3, and each it moved the law dramatically in a rightward direction. The past term, the one right before this one, upcoming, looks different. It's true that if you look at the 3 most high-profile cases, including the Harvard affirmative action case and others, you see the same 6-3 divide, and you see the same movement in a decidedly rightward direction. But if you look at the next set of cases, some of which may have been just as important, if not more important, you see a very different picture. The court rejected the independent state legislature theory 6-2. It rejected an effort to gut Section 2 of the Voting Rights Act 5-4, and it rejected an assault on Congress's power over Indian affairs 7-2. Those results and others are evidence of an emerging 3-3 court with the center block of conservatives consisting of the Chief Justice, Justice Kavanaugh, and Justice Barrett, very often siding with the other 3 conservatives, but sometimes joining the justices on the left side of the court. The question for this term, or one of the questions for this term, is whether last year's voting pattern will hold or whether the court will snap back to a 6-3 court. We have an amazing panel here to discuss some of the cases that will provide the answer to that question. In alphabetical order, they are Professors Fredrickson, Goodwin, Lederman, and Wolfman. They will each present 1 case, and then once all 4 cases are presented, we'll take questions from the audience. So why don't we move in the direction of alphabetical order and start with Professor Fredrickson.
Okay, well, great to be here. It's great to see so many of you, who many of you I've already seen today, which is much more fun even. So I'm to talk about a case that perhaps you may find as troubling as I do. A United States versus Rahimi. And this deals with firearm restrictions in domestic violence cases. And specifically the question here is whether a federal statute, 18 U.S.C. section 922G8, which says that people who are subject to domestic violence restraining orders may not possess firearms, whether that violates the Second Amendment on its face. In 2022, as we know, in the New York State Rifle and Pistol Association, in the Bruin case, the court held that gun regulation should be examined through the lens of the nation's history of firearm laws. And so the question here today is obviously whether a domestic violence restraining order is the kind of regulation that is or is not consistent with our history of firearm laws. So how will the court determine whether or not this is a close enough analogy to what has existed in the past? So let me just give you a little of the facts. It's kind of horrifying, so I apologize for that, but in some ways that's why this case presents such an important question about the reach of the Bruin decision. What can really be placed in this rubric of kind of historical analogies? So Zaki Rahimi, pretty violent guy. He is a Texas man who in 2019 was with his girlfriend and knocked her down in a parking lot and dragged her back to his car where she hit her head against the dashboard. In a telephone call after the incident, he told her that he would shoot her if she told anyone about the assault. So she gets, a couple months later, a Texas state to issue a domestic violence restraining order against Rahimi. And the order also barred him from possessing a gun and warned him that while doing so, the order was in effect could be a federal felony. So while this order is still in effect, Rahimi goes out and he's a suspect in a series of shootings. The police search his home pursuant to a warrant and found, among other things, a pistol, rifle, ammunition, along with a copy of the restraining order. And so he was charged with violating that federal ban on the possession of a firearm by anyone subject to a domestic violence restraining order. And he pleaded guilty, was sentenced to just over 6 years in prison, followed by 3 years of supervised release. Now, he appeals his conviction, and the Fifth Circuit initially upholds his conviction, but after the Bruin case, it issues a new opinion that threw out the original conviction, finding the law was unconstitutional, and saying that despite the restraining order, Rahimi retained his right to bear arms under the Second Amendment, because this domestic violence provision was not consistent with the country's historical tradition of regulating firearms. So this is now in front of the Supreme Court. The Biden administration is arguing that the law is constitutional, saying that the government has long disarmed individuals who pose a threat to the safety of others, whereas Rahimi is arguing that, in fact, that there is no historical analogy that's close enough, and therefore the court should strike down the law. That essentially these domestic violence restraining orders are not part of the history and tradition of gun regulations. The question really comes down to this issue of what is a close enough analogy. Does it have to be specifically domestic violence related, or is it simply that there were laws in the past restricting violent individuals, those who've been judged violent, not to be able to have guns? Now, there's also a Commerce Clause challenge, but I'm going to leave it under the Second Amendment. So, anyway, that's the case.
So, do you have a sense of where the court may end up here, or not?
I think this is such an outlier case. Or I shouldn't say it's an outlier, but it presents such awful facts. I think the court is not going to suggest that that Rahimi, that the domestic violence restraining order is not a permissible regulation under his. I think it would be such a way of blowing up the Bruin decision and making it perhaps as radical as many of us already think that it is. This would be the case that would show how radical it is. So I think they're likely to say that there's enough of a close analogy that we've held that there has been state regulation finding that violent individuals can be prevented from owning guns. But, I hope I'm not wrong.
No, so we can always be wrong in our predictions, but we make them nonetheless. And the way I'm hearing you, and I think this is what you're saying, they will try to do it, if they reach that result, within the contours of the Bruin way of thinking about this, and that we can't expect that this will pose such a challenge to the way Bruin has gone about setting out what's to be done, that there would be any modification or clarification maybe of what Bruin had in mind.
It's possible that they might try and kind of chip around the edges and suggest that they never meant it to be, to throw out everything, that as long as it bears some close enough relationship. But I guess I'm more inclined to think that they're going to draw this one narrowly and say that domestic violence, people who have been found to be, now this wasn't a criminal conviction, it was actually a civil restraining order, but that he had been determined to be violent in that context, and that's close enough to restrictions on violent individuals in the past.
Okay.
Whereas not throwing out the historical framework.
Right. Okay, on to the next. Professor Goodwin.
All right, pleasure to be with you all today. So the case that I'm taking up is the Danko Laboratories and Alliance for Hippocratic Medicine and U.S. Food and Drug Administration, the Alliance for Hippocratic Medicine. And this case really starts with the Dobbs decision. Without Dobbs, we don't have this particular case in front of us. So, to talk just briefly about the Dobbs decision, it's a 2022 decision from the United States Supreme Court. Many of you may remember when there was a draft opinion that was leaked, and there was a question whether that leaked opinion would ultimately serve as a reflection of the court's opinion, and it did. And in that decision, the Supreme Court struck down Roe v. Wade and Planned Parenthood v. Casey. Justice Alito wrote the opinion for the Supreme Court. In that opinion, Justice Alito said that Roe v. Wade was an egregious decision, had been egregiously decided by the Supreme Court in 1973, which then means we need to talk just a moment then about Roe v. Wade very quickly. Roe v. Wade was a 7-2 opinion, not a close decision in 1973. 5 of the 7 justices who were part of the Roe decision affirming the ability to be able to terminate a pregnancy were Republican appointed, which gives you some sense about how different the time frames just are. The justice who authored the opinion in Roe v. Wade was Justice Blackmun, who was actually nominated to the court by President Richard Nixon, so not a liberal. Planned Parenthood v. Casey then comes a couple decades later. It's a case that upholds Roe v. Wade. It too fundamentally turns on conservatives on the court upholding it, people like Justice Kennedy, Sandra Day O'Connor, etc. So in 2022 then, the Supreme Court overturns those decisions, nearly 50 years of precedent. And if you go back even further to perhaps Skinner v. Oklahoma, 1942, in a 9-0 opinion that is then authored by Justice Douglas, the court says that there is a human right to determine your own reproductive destiny. Now, it's a case that involves a man who's a chicken thief. Probably you're getting to the case if you haven't already gotten to it. And an Oklahoma law that says that individuals who are petty thieves can be coercively sterilized because they're unfit. Not the kind of people that we want in our society to be reproducing, but the law makes an exception for thieves who happen to commit big crimes, like people who happen to embezzle, like people who happen to swindle people out of millions and millions of dollars. And the court says that the state has no right or authority to interfere with the civil rights of individuals to be able to determine their own reproductive future. But to know that case then is to know one other, and then we'll get to this case, is to know the 1927 decision in Buck v. Bell, which the court doesn't overturn in Skinner v. Oklahoma. Now, Buck v. Bell is a case that is an 8-1 decision in the Supreme Court where the court upholds a Virginia law, a Virginia model eugenics law that provides for the compulsory sterilization of individuals who are considered to be unfit. It's a case where then Justice Oliver Wendell Holmes, one of the most revered jurists to serve on the Supreme Court, says that 3 generations of imbeciles are enough. Better than to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. And from there, tens of thousands of Americans are sterilized. Interestingly enough, these happen to be predominantly poor white Americans. All right, now fast forward then from 1942 to 2022, and we have the overturning of Roe v. Wade in the Supreme Court saying that Roe is an egregious decision. Justice Alito says in that opinion, and there are concurrences in that decision, that these are matters that should be left to the states. Now, notably, this is a case that's brought by the state of Mississippi, and there was a lower court order by Judge Carlton Reeves that had not allowed a Mississippi law to go into effect. That Mississippi law had banned abortions after 15 weeks of pregnancy, no exceptions for rape or incest. But Mississippi was looking for something more, which was the overturning of Roe v. Wade entirely. And that is what the decision granted, but allowed for states to set their own laws and regulations. Some of this we see now in the aftermath. So then we have the petitioners in this case bringing a suit for mifepristone, bringing a case saying that mifepristone, which is one of a 2-part drug regimen that's part of the medication abortion, that the drug was rushed to the market by the Food and Drug Administration and that the drug is unsafe. In 2000, the FDA approved the drug for use in the United States. Now, it had already been approved for decades before in Europe, but at that time, the FDA did approve its use. Now, what's interesting is the argumentation that it was a rush to the market and that it was unsafe, which is that years' worth of evidence to be able to test. Well, has it been unsafe? What's been the nature of people's conditions, any kind of consequences of using this drug in the last 23 years? And there are also questions with regard to whether the plaintiffs should have standing in this case as well. Judge Kaczmarek, the case was brought in Amarillo, Texas, before a district court judge, and this district court judge issued not a preliminary injunction, but a stay against this drug being in the marketplace. That was appealed up to the United States Supreme Court, and the court issued a stay against that district court ruling. Now, the case has gone to the Fifth Circuit, and what the Fifth Circuit has done is to say that, well, what should happen is that the FDA, which had expanded the use of mifepristone, in 2000, it was that mifepristone could be used if it was to part of this drug regimen to terminate a pregnancy up to 7 weeks. It could be used if a doctor issued the prescription. It could be used if there were 3 visits to a medical office. But since that time, the FDA had then expanded the ways in which people could get access to this particular drug, such that individuals who do not happen to be licensed doctors but otherwise licensed medical professionals could dispense the drug. The drug could be dispensed through the use of at a pharmacy, through a pharmacist, reducing the number of times in which an individual would actually have to be seen in order to be able to get the drug. The use of telemedicine to be able to have access to this. The Fifth Circuit said that basically what should happen is before the FDA made these changes in 2016, that mifepristone could stay on the market just as of the pre-2016 standards, right? That has not gone into effect. The case will be heard by the United States Supreme Court. There are a number of issues that arise in this particular case. One of them being the reach of administrative agencies and individuals to be able to challenge agency rulings. An issue of standing, given that the FDA ruling had been so long ago, 23 years, could these people possibly have standing? Who are the people that said that they have that they actually have an injury in this case? One of the litigants happens to be a dentist, not a person who would actually perform abortions. Can a person claim that they have an injury if in fact they don't do this particular kind of work? They don't provide these services to individuals who might utilize them. And then finally, there's some questions with regard to facts, which, you know, there are questions as to how facts matter across any number of these cases. And this says then something about Justice Roberts, the Chief Justice, and very recent abortion cases aside from Dobbs itself. In 2016, there was a case called Whole Woman's Health v. Hellerstedt. It was a case where the United States Supreme Court struck down two Texas laws that are otherwise called TRAP laws, targeted regulations of abortion providers. The Supreme Court said that those two laws, one that mandated that clinics in Texas be retrofitted to essentially be like emergency rooms. This basically implied that abortions were very unsafe. And the second thing is that persons that provide abortions, gynecologists, have admitting privileges at nearby hospitals. Justice Breyer wrote the decision in that case, which was 6-3. And there are a couple of pieces of information that I think are relevant for that case, and then one that came just a couple of years before Dobbs. So Justice Breyer, based on a very extensive district court record, where the district court brings in all of the facts, says that what we have from this factual record is to know that a person is 14 times, a woman is 14 times more likely to die by carrying a pregnancy to term than by having an abortion. Abortions are very safe. Abortions are safer than having tonsillectomies, and the court gives any number of other comparative types of medical procedures. And this was basically to raise the question as to whether Texas was really sincere in what it was arguing, that abortions are very dangerous. And the point of what it was doing was to protect the health and safety of people who would have abortions. In a case then a couple years later called June Medical v. Rousseau, and this is a case that then is important for thinking about how the court might rule in this term. So this is a case right before Justice Ruth Bader Ginsburg dies. And it's a case in which Justice Roberts sides with the liberals on the court to strike down a law from Louisiana, which is pretty similar, almost verbatim, to the law that the court had struck down involving the Texas case. And Roberts sides with the liberals. One could argue, well, why does Roberts do this? Because he certainly had not had a history necessarily with being a champion of reproductive rights on the court. But one might say that this was because precedent mattered. This was right before Ruth Bader Ginsburg died, and Whole Woman's Health v. Hellerstedt was 2016, so we're talking about a case from the 2019-2020 term. It's going to be interesting to see how Roberts then rules the side he takes in this particular case, and I'll end it right there.
So, I guess I'll ask the same start-off question is, do you have a sense of how the court might come out on this case or not?
I do. So one thing is that this is a case in which the conservatives, the real question is how the conservatives would come out on this, because the liberals, Kagan, Sotomayor, Justice Ketanji Brown Jackson, would be those that would decide against the litigants in this case that would say that mifepristone should come off the marketplace, or those that say just hold the FDA to the pre-2016 rulings. The question is whether the conservatives might join them, and what's at stake. Notably in this case, that those that are a part of this litigation include the company that has brought this drug to the marketplace. And that's a distinction. This is not then just a case about doctors who perform abortions or who would prescribe this medication. It's not a case then just about people who would seek to use this medication. But it ends up being a case that in some fundamental ways questions the efficacy of the drug that this company has put on the marketplace. And to the extent that that has any kind of meaning in this case and for other particular companies that might find themselves implicated in the way in which these cases are going, then I think that there might be conservatives on the court who might side with the liberals. A very long way of saying that, but like all of those little pieces matter.
Well, so it sounds like you think they may come together on the merits of the FDA's decision rather than cut it off at the threshold of standing, or do you think that coalition might also produce a standing ruling here?
One might hope that there is greater clarification with regard to standing, particularly after this last term where standing seems to be up in the air, and even in this case too. I mean, certainly on the merits, I think that the FDA has it, but it's embarrassing where standing is currently, particularly given the last Supreme Court term, where there was a litigant that claimed that there was an injury that she had in providing services for LGBTQ individuals, and it turned out to be a bit of a hoax altogether.
Okay, our next presenter, Professor Lederman.
Thanks, good to see you all. Thanks for coming out and sitting around before the ice cream. So I'm going to talk not about one case, but in some respects about 5, although 2 of them I'm really only going to say a couple words about at the very end. They're not on your list. State action questions about public officials who set up Facebook and Twitter accounts, and whether when they exclude certain of their constituents from being able to comment on it, are they state actors? Are they subject to First Amendment constraints? I'm not going to say much more than that, but wanted you to know that those cases are before the court, and if you have questions about them, we can take that in the Q&A. But all 5 of these cases are about the free speech clause in some respect of the First Amendment, which, you know, the typical case we think about is 2 parties, the government and a private actor. The private actor wants to speak, the government restricts the speech. The question is whether the Constitution allows that. But in fact, over the years, over the centuries, a number of the court's decisions, and many of its most important decisions, involve cases in which there are more than 2 parties. And in particular, they're about regulation, government interaction with what we might call intermediaries or conduits of private speech, right? The government tries to regulate those who either facilitate or coordinate or edit or curate is the verb of the day when it comes to the social media platforms, the speech. So think about all this. There are tons of laws going back to the beginning of the Republic, regulating telegraphs, regulating Federal Express, regulating booksellers, book distributors, cable companies, streaming services, ISPs, private museums, private libraries, student recruitment fairs, right? Like what this school does when it invites potential employers in to talk to you. It's facilitating the speech of third parties. Parade organizers who are trying to organize a parade with private parties who are appearing in the parade. This is just a little slice of this sort of thing, but it can just get you to thinking about how the government there's often more of a triangle, right? Three or more parties involved. There are the individual speakers, those who are coordinating or editing or facilitating their speech, and the government. And these cases, not the two that I mentioned at the top, but the other ones that are described in your sheet, are about the newest, or one of the newest forms and one of the most important modern forms of intermediaries, and that is social media platforms, right? What the platform formerly known as Twitter and Facebook and Google and the like. You might think search engines aren't really involved here, but it's a similar sort of thing, right? And so the issues come up in two very distinct ways. It's very complicated. I'm not going to go into all the details, but be happy to talk to you afterwards or in future days about these cases. But in some of the cases, individuals are complaining that the government, the federal government, has influenced the social media platforms to disfavor their speech. Think about it, Donald Trump was kicked off of Twitter, right? Certain posts were taken down because of that. Most importantly, the social media platforms, as you know, use algorithms and other means of deciding which private speech to push to which audiences. You guys all have feeds. You get certain things in your feeds, different from what someone else gets. It can be based on various different things, right? The intermediaries, the networks, decide how to determine whose speech goes to which listeners, okay? And in one of these cases, the one that the court will probably issue a decision on in the next few days, because the Fifth Circuit, since I drafted that, just yesterday, the Fifth Circuit issued a new decision in this case. The private parties are complaining that the Trump and Biden administration officials tried too much to influence or coerce these social media platforms to disfavor certain speech, to take it off. And for instance, those sorts of things that I just mentioned. Now, they are not suing Google and Twitter and Meta, Facebook, or anything like that. They're suing the federal officials, arguing that they violated the First Amendment when they tried to influence these platforms to take down what about 95% of the case involves information or posts and tweets that the federal government thought involved misinformation about COVID, about what time the election polling places were open, about mail-in ballots, about election posts being made by Russian officials and the like. So there was a lot of effort being made for good reason by health officials, by other officials, by election officials, by the FBI. This happens every day in not just the federal government, but governments around the country, to try to influence what these private social networks put on their sites to prevent them from, in the government's view, misleading the audience into thinking that certain things are true when in the government's view they aren't, leading to dangerous social outcomes, right? Leading to people engaging in behavior with respect to COVID that was unhealthy for them. And so they would bring certain kinds of either influence or pressure to bear upon these social networks to do this. Sometimes using quite harsh language. You're letting people die, you're contributing to this. Now, what's interesting in this case is the platforms are not really in the case at all. So far, they haven't really even appeared as amicus in the case. And this is a case in which, from all that we can tell, the platforms are very comfortable with the decisions that they made in reaction to the government speech, the government's efforts to change what they were doing. They want to exclude what they consider to be false information from your feeds, right? They don't want people to be saying things that are wrong about when elections are held or which drugs will help deal with COVID-19 or whether masking is effective or not. They agree that what they consider to be misinformation ought to be either excluded or at least disfavored on their websites, and they were persuaded in some cases, and not in others, by the federal government to take those steps. So some of the folks whose posts were taken off the sites and 2 states, we won't get into why the states are in the case, but 2 states complained and sought an injunction against federal officials in several different agencies. The district court granted an extraordinarily broad injunction that was cut back somewhat, at least on the surface, by the Court of Appeals for the Fifth Circuit. And they just issued an expanded injunction yesterday to cover yet another agency involved in election-related speech. But predominantly it's about folks in the White House, like the press secretary and others in the president's COVID task force, the Surgeon General, the Centers for Disease Control, and the FBI, from taking these steps. It's an injunction against them from, in the court's words, either coercing or significantly encouraging private social media networks to take down or to disfavor certain speech. Now, this case right now is on a motion. The Fifth Circuit has delayed the effectiveness of the injunction for 10 days. There's a pending motion up there from the Solicitor General to undo this injunction, and I suspect in the next 10 days the court will probably grant the Solicitor General's motion. They may also take the case on the merits and ask that it be briefed and argued, right, in this term. They might put it off if they don't want to get deeply into this. But the concern here is that this is the kind of thing government officials do every day. The Fifth Circuit thought it was viewpoint discrimination, right? Like for the government, this is just a viewpoint. Whether the polling place closes at 6 or 8 o'clock is just a viewpoint, right? And well, so in fairness, if this were, right, the National Mall and people were just out there on Speaker's Corner on a soapbox, they have a constitutional right to lie about or to give their views about when polling places are open or which COVID remedies are effective and which aren't. Okay, and the government could not stop them from doing those things. That's protected speech. But Twitter and Facebook and the like have no real desire to facilitate that sort of thing. They don't want to be at least partially responsible for harmful outcomes in voting or in treating a pandemic or that sort of thing. But nevertheless, the Court of Appeals held that the Biden administration, and even before that Trump administration officials, had done too much to affect the decisions that these platforms were making. And the government's going to go in and say this doesn't raise a First Amendment problem at all, that this is not the government coercing private parties to engage in speech they don't want to engage in. And the leading case is a case called Bantam Books from the early 1960s, in which a Rhode Island obscenity commission went to a book distributor, that they would be the intermediary in this case, a book distributor, and told them that they thought that several of the books that they were distributing to bookstores and others in Rhode Island might contain illegal obscenity. All right, and they threatened that if you don't stop distributing those books, we're going to ask the Rhode Island criminal law authorities to come prosecute you for distributing obscenity. Now, the distributor there did not agree that these books were obscene. That distributor didn't think it was doing anything illegal, but it capitulated to the government's threats, actual coercion, the threat of actual criminal sanction. And the court held that that was unconstitutional even before there was any prosecution, that effectively the state of Rhode Island had coerced this intermediary to do something the intermediary did not want to do, and in so doing suppress the speech of others, namely the publishers and the authors whose books were being distributed by this distributor. The court was a little unclear on whose First Amendment rights were being violated. They didn't really think in those terms at the time, whether it was the distributor who was not a party in the case or the publishers who were the ones that brought the lawsuit. So that's the leading case, but this injunction, the court, on its face, doesn't sound so bad. The government can't coerce intermediaries to suppress speech of third parties. But the Court of Appeals understanding what counts as coercion and significant encouragement is extraordinarily broad. For instance, the FBI encouraged these platforms not to put up this speech about U.S. elections by Russian agents acting secretly, and not to put up misinformation about polling places and mail-in ballot rules. The court held that that was coercive because the FBI is a law enforcement agency, and who knows, maybe they could prosecute these intermediaries if they didn't take down the speech. I'll just be frank, I think that's a ridiculous theory about what is impermissible. But that's basically the issue in that case. The other cases, which the court has already granted and which will almost certainly be argued in February, the court just granted certiorari of them, are almost the flip side. In that case, plaintiffs didn't go into court to complain about something, they went to legislatures. The legislatures, the folks who thought they were being disfavored by these platforms, went to the Texas and Florida legislatures. And they asked them to pass legislation, which they did, to prohibit these intermediaries, these platforms, from using various different kinds of viewpoint or speaker-based rules to disfavor speech. Now, those cases are largely being described, like the other one, as being about kicking people off the platforms, deplatforming them and the like. But what's really at stake there is the platform's use of algorithms and other criteria to decide when your speech is pushed out to others. So I used to have a certain number of Twitter followers, but I was away in the government for 30 months and I stopped tweeting, so now when I tweet, no one except probably the two people in this room see my tweets because Elon Musk doesn't send them out for whatever reason. I don't think it's that he doesn't like what I'm saying, although he probably wouldn't, but it doesn't matter, it's just like pro-Olivia Rodrigo stuff. It's okay, it's fine. But now no one sees my tweets, right? Because X has decided for whatever reasons, because I haven't had a lot of people reading my tweets, or I haven't paid them their $8, or whatever it is, they've decided Lederman's posts are not going to be the ones that get pushed to anybody, right? So but if that were done based on the substance of my posts, the Florida and Texas statutes would appear to say that Twitter couldn't do that, right? That they have to treat my posts equally. So this raises a big question about a government, here state governments, regulating these intermediaries to tell them that they can't use content and subject and speaker-based rules to decide who will be on the platform, but more importantly, how the speech will be disseminated to the readers. And they're coming in and they're saying, hey, we are effectively analogous to newspapers, right? We are, yes, it's not our speech, but we decide what the speech looks like. We are curating it. We're curating other people's speech in a way that we think is most effective for the audiences that are viewing the speech. And we have a First Amendment right to do that. Even though it's not our speech, we have a First Amendment right to decide how third-party speeches should be presented and whether it should be presented to the audiences that have signed up for our services. The analogy to newspapers I don't think is very good for several reasons. First of all, this is not in any way their speech. They don't affirmatively select 99% or virtually any of the speech that goes on their websites, right? When you guys tweet, when you go on Facebook, those entities don't even know what you're saying most of the time, let alone making a decision that it should go on, let alone taking responsibility for it. They often don't know. They claim publicly to be establishing only like a public forum. They claim to be promoting a flourishing of speech by everyone, right? Allowing everyone to speak. We are the new public fora. We are not responsible. And they actually convinced Congress to pass the statute colloquially known as Section 230 of the Communications Decency Act to say we can't be held responsible for what gets posted on our sites because we aren't the editors, we aren't the speakers, it's not our speech. So the newspaper analogy I think doesn't work, and quite frankly, the briefs so far and the opinions have been all full of analogies to all these other kinds of intermediaries over the years, and I think they're all none of them is a very good analogy. What the court has done over time, often not so well, is come up with new First Amendment doctrinal structures to deal with new kinds of intermediaries. The thing that might be most analogous here is cable operators. There was a federal law requiring cable operators to handle at least some public broadcast, like local public broadcasting stations on their cable systems. The court upheld that statute, that still exists. I don't think the court's going to rule the same way here. It may use that doctrinal structure, but most of it I think is missing here in the so far. We'll see what the briefs look like. What's missing here so far is the real harm that would be done if the Texas and Florida statutes required pure viewpoint content-based neutrality on these things. If social networks were not able to at least modestly curate their what gets sent out, to cut out, right, hate speech, to cut out speech encouraging terrorism, to cut out speech that tells you that lies about when polling places are open and the like. These platforms will become useless, right? We've all seen that unmoderated, truly unmoderated forms of internet operations quickly become useless. They become controlled by trolls and others, and everyone stops using them. We need to be able to give, this is going to be the argument, we need to be able to give, maybe the First Amendment requires that these platforms be allowed at least this modest ability to temper what goes out and what gets pushed out in order to make these effective modes of communication, because otherwise I think the platforms will argue that they will be completely undermined. So if I had to predict, Irv, I would say that these statutes, the court will hold that the Florida and Texas statutes are unconstitutional. But I think almost more important than the holding is going to be the court's decision about precisely what kind of doctrinal framework to use, because this kind of question, it's a very novel question, and it will probably govern a lot of analogous sorts of attempts to regulate going forward by both the federal and the state governments of these platforms. And I think the court should be very, very cautious about ruling very broadly one way or the other. I think it's really a very open question what framework they will adopt and what they ought to adopt. I'm still struggling with it myself.
All right. So
I anticipated the predictive question. I'm curious whether any of you disagree with my prediction.
You want me to ask him a question?
Do you agree with my prediction?
Yeah, I'm not in the prediction business.
Oh! Who's in Professor Gornstein's class, right? You guys know.
Well, what about in the first set of cases?
Well, I thought you snuck in your prediction and said the court would stay. Is that what you said?
Yeah, but then it was good.
I think the court, if it reaches the merits, which it probably will eventually on this on the federal government coercion, right? The federal government coercing cases, I think they will say, but not unanimously, that the federal government is not acting unconstitutionally in trying to encourage actors to take off speech or to disfavor speech on their platforms when they are not complaining about it. Right? They are not coming in and saying, like this distributor in Bantam Books did, man, we really wanted to put this on our sites, but the federal government shook us down. Right? We don't know what they will say in their briefs yet, but I suspect they will say, we agree, we don't want our platforms to be servicing misinformation of certain kinds. And we are comfortable with that.
What if we don't hear from them? We haven't so far, right?
It's a really interesting question. You know, they made a tactical judgment not to file a brief at this preliminary shadow docket stay motion stage. Even though I didn't want to get into this because it's too complicated, the logic of the Court of Appeals holding is actually that the platforms themselves are state actors who are bound by First Amendment constraints. That's a holding they will want to resist tooth and nail, and I can't imagine they will not appear on the merits in this case. And I suspect they will claim that the federal government did nothing wrong with respect to them. And I think because of that, the court is likely to hold that what the federal government did here was not unconstitutional. But it may depend on a lot of variables, such as that one.
All right. Professor Wolfman.
Hello, I'm here to talk about Muldrow versus the City of St. Louis. I'm in a little different position here. Tanya Muldrow is my client. So I'll describe a little bit about the case and then describe a little bit about the legal issue in the case, but I'll do it quite quickly and then I'll do something that's a little different. I'm going to describe sort of how this case was built and what we did here in the clinic here at Georgetown to sort of build the arguments that I'll sketch out to you very briefly. Thank you, Marty. So Tanya Muldrow, our client, claims this is very quite simple actually, that she was transferred from being sort of a big sergeant in the headquarters of the St. Louis Police Department investigating high-profile crimes to being a line investigator in a district office in St. Louis on account of her sex, that there was sex discrimination. That's what she alleged. And she sued under the principal federal employment discrimination statute that many of you have probably heard of, called Title VII. And I just want to read to you the key words of it. It shall be an unlawful employment practice for an employer to fail to refuse to hire someone or to fire someone or otherwise discriminate against them with respect to their compensation, their terms, conditions, or privileges of employment. And that's what the statute says, pretty basic language. So you'd think that if Muldrow can show that she was discriminated against, that is, that she was transferred on account of her sex, that she would win. But the Eighth Circuit held, and this is not unlike what courts around the country have been doing for 30 years, 35 years really, that even if the transfer occurred because she's female, because of her sex, that she loses unless she can show the transfer imposes significant disadvantage upon her. And the Supreme Court granted cert on that question. In other words, does there have to be an additional court determination of significant disadvantage for someone to win under the words of the statute? I think, if you heard the words of the statute, I was trying to read them slowly, they don't contain the word significant disadvantage.
It's in your handout. The statute's in the handout.
I'm sorry, what?
It's
The
in the
language is
handout.
that they have it in front.
Oh, they have it in front of them, good. So I shouldn't have read it. So in any event, I said this has been going on around the country for several decades, and they use different formulations. The courts use different formulations. They ask, was there a material disadvantage? Was this an ultimate action? Was it a significant disadvantage? Did it impose materially significant harm? Was it objectively tangible? That was the DC Circuit's version until recently. But they all came to the same thing, that they didn't appear in the statute, and they made it more difficult for the plaintiff to prevail. And they added something that wasn't in the words of the statute, as I said. And so this was unchallenged for a long time. This first came to my attention over a decade ago when I was running a different clinic, and I was doing even more employment discrimination cases than I'm doing now. And I ran into a case that I was working on here in the District of Columbia, in which a person had been discriminated against, they alleged, on the basis of not being trained the same as someone else. This was a black employee said the white employees got training and the black employees did not, including himself. And there was doctrine here in the DC Circuit that, training is not something that, discriminatory training is not something, to use the legal term, actionable under the statute unless you can show that it imposes some objectively tangible harm. Again, I'll say it again, those words don't appear in the statute. So that bothered me, and we tried to work our way around it. In that case, we were in a district court. We had no basis to ignore the DC Circuit. And then it came up again about 4 or 5 years ago when we were writing an amicus brief at the cert stage in a cert petition out of the Fifth Circuit that had a particularly stringent version of this rule. And that case went away and cert wasn't granted. And then we just started litigating these cases sort of as a sidelight to our other litigation in our clinic all over the country. 3 or 4 of them in the Fifth Circuit, in the Ninth Circuit, a couple in the Eighth Circuit, one in the 11th Circuit. And slowly but surely, and you might call this like progressive textualism, we got the ear of people who, and even judges who would be viewed otherwise as conservative. For instance, we just won this issue en banc in the Fifth Circuit with only 2 dissents, essentially. And if anybody knows about the Fifth Circuit, it's hard to get a progressive result in the Fifth Circuit. In any event, we built up what appeared to be a circuit split, and in this case, the Eighth Circuit was held that there was this additional requirement outside of the words of the text that made it such that a transfer decision, even if discriminatory, was not actionable under Title VII, and that was in direct conflict with what the DC Circuit held en banc last year in a case of ours, overturning the rule in the DC Circuit. So I thought that would be a little interesting to sort of describe to you how a kind of case like this might get built up in the courts, rather than going into the detail of the textual analysis, because really it's possible that this case could be decided on not much more than what I've already told you. The statute says this. It doesn't contain an additional material adversity or significant impact requirement. No additional significant harm requirement other than what the words of the statute say. And that might be that. Or maybe it'll get more complicated. I'm just going to say 2 more things, and then I'll be quiet, which is this. The case posed an interesting tactical judgment, I think, for a litigator. We ended up deciding to write an opening brief in the Supreme Court that in significant part looked like an answering brief, really. I mean, we made our affirmative argument, but then we surfaced and answered what we were pretty sure to be the arguments that the other side would raise. Now, a good opening brief tends to do that anyway because you want to make clear your credibility as an advocate. But this did it more than normal because there was no reason to hide the ball. The issues had been surfaced all over the country in recent months in all these many cases. So that's just one interesting thing that I thought I would mention. And the other is this, which is that another way to look at this statute, you heard me again, I guess the statute is reproduced in your materials, which I had forgotten. But the statute says you can't fire someone for a discriminatory reason, and you can't fail to hire them for a discriminatory reason. And of course, the defendant is going to say that what goes on in between compensation and particularly terms, conditions, and privileges of employment are narrow and therefore might exclude a person like my client. But another way to look at that statute is that Congress was trying to eradicate, or as best it could, discrimination. And what it was trying to do is if it was looking at hiring and firing, terms, conditions, and privileges is just a shorthand way of saying that we're also trying to eradicate discrimination in everything in between. In other words, in the interstices of between hiring and firing. And of course, that is largely our position. So that what you found in the cases all over the country that have been out there for 30 years, that this doctrine has infected all manner of ways in which an employer might discriminate. So it has been held that suspending someone with pay for an admittedly discriminatory reason is not actionable under Title VII. As I say, transferring someone for an admittedly discriminatory reason is in many circumstances not actionable. Giving someone the overnight shift as opposed to the day shift for an admittedly discriminatory reason is not actionable, and so on and so on and so on. So that's the case, and happy to talk to anybody about it at any time, and I'll be quiet.
So I don't want to ask you to predict the result of your own case.
Because I would not answer that. Yeah.
So, but I do want to ask you this question instead, which is, if you look at the statute and the statute doesn't say anything about significant disadvantage, why is it, or how did all of the circuits who had accessible to them this very same language, what explains in your mind why these circuits superimposed on this text this additional language? What's the best explanation for that? Is that something that can be...
I think I could talk about that, but the answer is, and I think that's a great question, and because it's, you might imagine this is something that I ask myself. And it's difficult because the vast majority of the cases don't even question it. They just say it. Now, there are a few cases that place this requirement in a couple Supreme Court precedents that we just think are off point, right? And, the answer is it's 25 of 5, and so you'll have to read our brief to see why those cases are not on point. But the more cynical explanation, is that the courts at the time, not being particularly textualist, were interested in narrowing the docket of Title VII employment discrimination cases, which do make up a significant part of the civil docket of the U.S. courts. Is that the kind of answer you were looking for?
What's the kind of answer?
So I will say this. This is a really interesting thing. Let me just say one other thing, which is that one of the times that we were talking to a plaintiff's lawyer about taking one of these cases up on appeal, in one of the circuits where we were successful in the last couple years, when we talked to the plaintiff's lawyer, he didn't even really know what we were talking about. So the problem had become so entrenched that some of the people actually thought these kinds of words were in the statute. And the reason you knew it was such an endemic, entrenched problem is that many of the plaintiff's lawyers believed it. And that really encouraged us to take this a step further.
Okay, so we're ready for questions from our student
Can you hear me
audience.
in the mic? Yeah, great. So if you have a question, could you let me know? Let's start towards the back here. Anybody hear me who have a question? I'm going to move forward. Nice to hear.
Hi. I have a question about the Fifth Circuit specifically, and just if any of you can speak to what you envision for kind of the future impact of so many of these cases coming out of the Fifth Circuit.
Well, it's a great question. The Fifth Circuit being one of the more conservative of the circuits that we have. It's the Fifth Circuit that actually brought the challenge, which in some ways was a challenge to the court itself, in the June Medical v. Rousseau case. It's an interesting case when you think about the following, right? So the Supreme Court, just a couple years before it, strikes down exactly the law that the Fifth Circuit says is okay. And in a way, you can think about it such as, let's say that the Supreme Court has ruled in Brown v. Board of Education. And then let's say that in Louisiana, they say, well, that applied to Topeka, Kansas. It doesn't apply to us in Louisiana. And so we're going to bring this forward. In part, one might think that Justice Roberts' rebuke, as I mentioned, was one that related to precedent. It might also relate to something about the legitimacy of the court itself, right? And the legitimacy of the court vis-a-vis lower courts as well, including the Fifth Circuit. And now again, we have the Fifth Circuit in the case that I reported on today. And so it's a great question. I'll turn it over to my fellow panelists. It's unique in that way, perhaps.
So I just wanted to know, is it true that all of the cases except Professors Wolfman's are coming from the Fifth Circuit, and the Fifth Circuit, as you said, had at one time the most extreme version of the significant disadvantage test? Yeah.
And just overturned it and banked it 4 or 5 weeks ago.
I do think this is going to be the term in which the Fifth Circuit, there are different sorts of conservative judges on the Fifth Circuit. In fact, they've articulated one of the most highly esteemed judges, a long-standing conservative member of the Fifth Circuit, wrote in an opinion last year that he thought his court was on fire, that his newer colleagues were completely out of control. They're writing extraordinary opinions that full disclosure, I worked on the Mifepristone case in the Department of Justice, so I'm not unbiased. But some of these decisions, the ones I described, the ones that Michele described, and others, whatever the merits of the judgments are, the rationales are quite self-consciously extraordinarily aggressive and dramatic in certain ways, right? They're very, very self-confident and dramatic. And I think this is going to be a term in which in these 3 cases and others, Jarchese, I guess there's one other, right, that's a big...
I think it's in the consumer finance.
Oh yeah, the CFPB case that was argued yesterday. That the court is going to largely rebuke the Fifth Circuit, maybe in all of the cases. But whether that has any impact on the way those judges act may well depend upon how unanimous or how overwhelming the Supreme Court's decisions are and what the tone or the rhetoric is of the court's rebuke. It could be that they will be proud to be rebuked, right? When they're a different breed of judges, and the audiences they are trying to reach, they might not be shamed at all if they lose all of these cases. Now, I don't know for sure that they'll lose all of the cases or most of them, but I think it's a definite possibility.
Another question.
Hello. I had a question for Professor Lederman on the social media regulation cases. You were talking about the most like example is cable companies for the framework. I'm just curious if you can elaborate a little bit of what other frameworks are out there and what other parallels there might be that is at the court's disposal right now.
It's a good question. I've told you why I think newspapers, which is what the platforms are largely relying upon, is not going to be very persuasive. On the other hand, the Fifth Circuit panel basically said there is no First Amendment right to edit and curate and present the speech of others at all. I think that rationale the Supreme Court will not accept. They will reject that. They will say there is some role, even if you are disclaiming that the speech is your own. So one thing is private museums, right? Imagine a state legislature passes a law saying the private museums in our state, they're putting out, paintings that are too religious or not religious enough, and their aesthetic judgments from this point forward have to be completely content neutral. don't have any doubt that the Supreme Court would say that's unconstitutional, even though none of the paintings are by the museums, right? It's other people's paintings. That might be the closest, although even there, they're selecting a handful of paintings from millions that are available. The oddity here is that the platforms allow 99% of the speech, and the important thing is, from their perspective, is the ability to be able to restrict or limit or especially not push out the 1% that in their view would radically transform the experience that the users have on those platforms. I don't know, I ask my fellow panelists, I'm not sure there is a great analogy. And if you go through the court's history, oftentimes it's faced without good analogies for new media. That's the interesting thing about new media. As they pop up, the old doctrines don't fit very nicely. And I think you have to look at how these networks work and what would happen if you either allowed or didn't allow states to regulate them, what it would do to the actual experiences of the users. I don't think they're going to be extraordinarily sympathetic to Elon Musk's First Amendment rights, but they will be very worried going in both directions about, first of all, is it unfair to users to get kicked off of Twitter? But on the other hand, if you regulate Twitter in a way that it becomes virtually useless, that's not good for anybody. And so I don't know that, do any of you think there's a really great analogy out there? I haven't seen it in the briefs, if there is. Do any of you think there's a great analogy? Write an amicus brief. Write it in the court. Right.
Let's have another question.
There doesn't need to be one.
Logical reason.
This is, I hate microphones, so I'm just going to talk a little louder. This is sort of in a similar vein, but one of the things that really bothers me about like the social media companies being treated, the curation of speech being treated as speech, is that as private companies, their goal is to maximize the user's attention, and in many ways, in terms of like algorithms and the way that social media works, also addiction. And so the purpose of curating is to make the user more addicted to using it. Do you think the court is going to consider addiction in any capacity for whether or not it's actually speech?
I think the court will see that as a virtue, that they, in order to make money, they have to give the consumer what they want, and they're trying to use algorithms that largely give them what, well, you're right. Now, obviously, they shape what people want, right? Advertising does that.
I think
Libraries do that.
I think you're also describing all speakers today, unfortunately. But anybody who has a site is trying to get people to click with their headlines. The Washington Post, you think they're not trying to addict people? The New York Times, they're not trying to addict people to their site?
The New York Times got
so
before the Post did.
I definitely think that is inherent if you're trying to speak for a profit. There's
But that was actually the case actually very recently on NPR. The person who was at the New York Times for some years before this sort of turned to other news media such as the Post, Wall Street Journal, etc., going to social media and whatnot. The New York Times got there first, and they talked about how very deliberate this was and how in some ways their being very deliberate also was a kind of luck, being able to then take on so much of the marketplace with getting people to click, be engaged and involved. Some of you may have even watched like New York Times videos. New York Times got to doing videos before other platforms like the Post, Journal, Wall Street Journal, etc. Did. And so to your point, Professor Gornstein, the point perhaps is getting the clicks, whether we call them addiction or call them getting clicks. And this relates to matters of TikTok, but we're not there.
I was just going to add one last thing, which is for any of you who may be publishing or may soon publish, you may realize that the writing process and the editing process are often very separate from the choice of the title process, and you may end up with a title that you never would have wanted on your piece, so you're very conscious of that. But that's because it's a different set of people who are thinking about that, because it is very much tied in to what is going to move the fastest.
Another question.
Hello, my name is Patrick Goodwin, and I'm a deaf student. Today, I want to ask you all about a case that's not on the list that you have. Today, the Supreme Court heard oral argument in an ADA Tesher case, and I wanted to ask, are any of you familiar with that case? And if so, do you think that the Supreme Court will pass it along because it's been needed by the lower courts? Or do you think they're going to issue an advisory opinion?
Did you read the transcript already? Yeah.
Sounds like it's yours.
So, Patrick, a lot of these students are in common law with Professor Gornstein and myself in Section 4. Did you teach this too, Atchison?
Yeah, well, we
Great.
did that.
So a lot of the students here have been engaged in this very interesting case, and any of you there today? And I saw 2 or 3 of you there today at the argument. Surprisingly, I think, there was much more receptivity by the justices, by a cross-section of justices, to declaring that the parties agree the case is moot and it would be an advisory opinion that either we can't issue or that we ought not to issue. I think that isn't what most of us expected the court to be, but at least there were some indications that even justices such as Thomas, Barrett, and Alito were very wary about reaching the standing question in that case. I don't know if any of you who were there saw it differently than that.
I hope so too. I hope so too.
I just want to mention for those of you who aren't familiar that case was the case for the disabled person who was trying to use the website was argued by another Georgetown professor, Professor Goodwin. So we have 2 professors with arguments this term, which is incredibly awesome.
So far.
We had one whose case was dismissed as moot in similar circumstances.
And then we have a third one.
Who's happy not to be appearing before the court. Yes.
Other questions?
I don't need the mic, so we'll be fine.
Make sure you speak so that people in
Yes,
the back can hear.
Professor Goodwin, I'm thinking about the Mifepristone case, and you alluded to one of the parties being the pharmaceutical company, which makes it a little bit different of a posture. I'm curious if you think this court will think about the commercial consequences of that, thinking that this is a pharmaceutical company, they've had an item on the market for so long. If this is stricken down, what would be the commercial ramifications of that?
Well, that's a great question, and it's Danko Laboratories that makes this drug. You know, the justices on the court are not immune to thinking about what happens, the universe of concerns that happen around them, even though we may sometimes think of judges and justices as being in their own silos. What makes this case interesting is not just about mifepristone and the fact that it's abortion. Although what's interesting is that the court in Dobbs said, we'll leave this to voters by Judge Kaczmarek striking down the use of mifepristone, or saying that, agreeing with the litigants in this case that it was rushed to market, that it was unsafe, then basically puts a thumb on the scale with regard to Dobbs. So that aside, let's keep in mind that we've been in a global pandemic, that there are vaccines that have come to the marketplace, that unlike any time prior in our nation's history, there is a growing consensus among some people that they should not vaccinate their children anymore, that their children don't need vaccines against measles, against smallpox, against any of these kinds of things. And so what's at risk in this case is not just thinking about the FDA and its authority with regard to this drug related to abortion, which there are 2 drugs that are used. This is one drug and there's another, misoprostol, that's used. But what about individuals that could bring suit saying that, look, we don't like name X vaccine being in the marketplace, and that we think that we might be able to find a specific federal district court judge in a particular location where it's only that judge who might agree with us, which is how some people think of Judge Kaczmarek, that there was a version of judge shopping, that there's this one judge who had written previously about anti-abortion views, During the nomination hearings, it actually removed one of the writings away that he was going to have published with the University of Texas Law School, and that had been an activist in this case. And so you might imagine that those who then are concerned about vaccines doing the same, finding a judge that might hold some sympathetic views. And given the satellite of those concerns, perhaps, that might influence some thinking of the justices.
We have another question over here, Professor Gornstein.
Sorry, this is a question for Professor Fredrickson. One of the arguments that was raised by Rahimi against some of the historical analogs for this actual question was that the analogs were all based on, or at the time were based on individualized proceedings based on the possible threat of the person to society that was being restricted. If the court is going to try to make a fact-based analysis anyways and say, well, in this case, it's just so brutal, we can't allow this, we can't say that this person is not to be restricted, is there any way for them to do that without opening the door to that same kind of fact-based analysis when it comes to possession by felons? Or even reducing Bruin back to the old kind of like means-end balance?
That's a great question. I think they can be, but that might be an area where they're willing to include former felons, the mentally ill, and so forth. Because it's already been, those have already been categories that in prior cases have been mentioned as being exceptions. So I think trying to cabinet to those categories who have been designated through some process as incompetent to have a firearm, either because they're violent, because they were formerly violent, adjudicated violent, because they have a mental illness, would be different from simply saying you can't have a handgun in your home for personal defense purposes. So I think that would definitely be a possibility and enable them to issue decisions that seemed more consonant with the American people, even though they don't go as far as many states and localities would want in terms of restrictions on concealed carry and so forth.
Other questions? No?
Others may disagree with me.
Oh, I'm sorry.
The only thing I would say is there's a couple of courts around the country who are starting to, courts of appeals, grapple with the felon laws, and at least the Third Circuit seems to have come to the conclusion that if it's a non-violent, completely non-violent felony, that may not be a sufficient justification for permanently taking someone's gun away. So that issue is going to reach the Supreme Court eventually. I'm sure the Solicitor General picked very carefully the Rahimi case rather than that case to take it first. But eventually, I do think the Solicitor General is going to have to take one of those Court of Appeals decisions that holds that you can't enforce the felon disenfranchisement. I mean, felon taking away guns from felons unless they're in some sense a violent felony. That is eventually going to reach the Supreme Court. Not this term, but next, probably.
Other questions? Set this down.
Another question about the Rahimi case. What about, I've heard the possibility floated of disposing of it on a due process argument, sort of to get out of an unpleasant set of facts. That Rahimi didn't get enough process, and so for that reason, it was unconstitutional to disarm him, but leave the broader question open. I know he agreed to one of these orders, but the other one he didn't, and I was wondering if you think there's any possibility of the court using that to get out of the slippery situation.
I don't know. I guess I would doubt it. I don't know. Again, if the other professors would disagree, but I think that they may find this as a useful way to make Bruin seem less extreme. But it's a facial challenge as well, so I'm not sure it really is pertinent.
So for those of you not familiar, the Supreme Court picks and chooses what questions it's going to decide, and it picked the Second Amendment here. It didn't pick the due process clause, and as far as I know, no argument has been surfaced by the defendant in this case that the court should decide the case based on a ground that he did not prevail on below and probably didn't present below for all I know. So,
Caroline, you mentioned a Commerce Clause challenge, but that's not before, is that before the court? No.
The defendant did present a Commerce Clause challenge, but the court only granted certiorari on the Second Amendment. So let's have one more question.
Yes, I have someone right here to get her the mic. If I can do it, almost. Can you set this down?
I'm wondering why, in the mifepristone case, why are they arguing that this case is cert-worthy?
Well, this is a case that came to the Supreme Court after the district court decision with the FDA for reasons that would seem obvious with the FDA, and the court issued a stay. And then the case, as I described, went back to the Fifth Circuit, and the court is now going to take up the case again, given the court is going to take up the case again, given that a stay is still upon that Fifth Circuit ruling. Would others want to speak more to that?
Again, with the caveat that I was in the government, so I'm just reflecting what the government's views are on why this is cert-worthy. Obviously, it's extraordinarily important for women's reproductive freedom, right? It's the use of mifepristone and misoprostol is going to become the dominant way that women in many jurisdictions.
And well, it already is.
And it already is. So it's got enormous. So it's on its merits. It's of enormous importance. But this sort of dovetails with your question. It's also the first time in which any court has held that the FDA has unlawfully approved the marketing of a drug anywhere, and that's why the entire pharmaceutical industry is going to get in. Absolutely, Brian. Yeah. Please
I just want to comment on that point,
which is a very good point, Sean.
Huh?
I was saying it's a very good point
It is
that
really
you raised.
excellent point, and I just want to comment on that because in a former life, before I was here, I did a lot of health and safety work, including challenging FDA conduct. And we always had to come up with different ways. We never thought we had a jus cosmera. So we would do FOIA litigation. We would help plaintiffs' lawyers sue. We would petition the FDA for labeling changes. But the idea of getting a drug off the market because that was approved as safe and effective was considered completely beyond the possibility for us or any other group or anyone who actually had standing, which of course is a problem in these other cases. So that is what to me is most shocking about these cases. Not most important. Marty is right, what's most important is the women's health ramifications, but what's most legally shocking is the idea that a federal judge has overturned a safety and efficacy determination of the FDA.
To put this in context, so in my class, biotechnology, bioethics, and the law, we study the FDA in part. And one of the things that you'll find is that in nearly 100-year history of the Food, Drug, and Cosmetic Act, the Supreme Court has consistently upheld matters brought to the court through the FDA, upheld whatever the rulings typically have been from the Food and Drug Administration, including when the Food and Drug Administration issued a ruling that tobacco-based products should be removed from the marketplace with a very robust fact record in that one case. It was that one case where the Supreme Court decided differently, and that was actually very, very shocking. So in a nearly 100-year history, pretty consistently, there has been deference to the Food and Drug Administration, and with this particular drug, even though the argument has been that this was a rush to the market and poor efficacy, the year that it came into the marketplace, this drug had been under review for 54 months and then approved. All of the other drugs that very year that had won approval had been reviewed for 18 months So the argument itself doesn't really hold water. And then following that is 23 years of usage in the United States. We have significant evidence in this country. We don't have to look abroad, but we could, but significant evidence in this country with regard to its efficacy. And those matters combined then make this such a case that is really so incredibly startling, and startling then for the manufacturers of these drugs, whose work then is called into question. You can imagine the manufacturer that now has to contend with this question: is the drug not efficacious? Is it hurting the people that it's meant to serve? And those facts are not in evidence at all, and I think all combined from what you've heard up here is why this is a case that the Supreme Court is taking up. Who knows how they'll rule?
All right, so
I was just gonna say, I would like to ask you all to join me in thanking our incredible staff. Thank you for your questions and your attention. Now, if my plans are in place, to go out on the terrace, there's a pool right.